Well, over the last 20 years, the EU's had a very significant impact on the framework of employment rights in the UK. Since the new Labour government signed the social chapter around 1997, there's been significant improvements over things like legislation in relation to equality and diversity, maternity and paternity, and working time. So I would say that the current framework of employment rights we have has been very significantly shaped by our membership of the EU, and more significantly our commitment to the social protection offered by the EU. It's difficult to say because the government has actually signalled that through what they're calling the Great Repeal Bill, the current framework of employment rights and other EU legislation is simply going to be converted into UK law. So at the point at which we leave the European Union, actually the framework of employment rights should simply be replicated and protected. However, what happens after that point is much more in doubt, and certainly the government are going to come under pressure from a range of interests to weaken certain aspects of employment legislation. Well, I think employees have reason to be concerned because I think there's a great deal of uncertainty. We have commitment from the government to protect employment rights generally, but we don't know which specific areas they are going to really focus their attention on. And certainly the overall debate over Brexit is still very much in its early days. So employees, I think, are uncertain and they're feeling concerned about what's going to happen to their employment rights. From an employer's perspective, I don't think that employers particularly are going to be concerned about this. And in the short term, I can't see there being increased employment protection as a result of Brexit. Well, I think it's going to be difficult. However, it certainly represents a chance to look at where we are at the moment. And I think one of the key problems with our existing system is that it lacks any very robust structure of enforcement. It's a very reactive system, so that employees are faced with trying to right the wrongs that have already been done to them and take claims against employers after their employment rights have already been breached. We've seen the introduction recently of employment tribunal fees, which has radically reduced the volume of litigation that's going through our employment tribunal system. So it's very questionable whether, despite our framework of employment legislation, whether employees have adequate opportunities to enforce that. So there is an opportunity to look again at those types of issues, and also perhaps to take a slightly broader look and look at whether there's a need for greater employee voice in the workplace. The government have already signalled their intention to look at legislation providing a voice for workers on boards of directors, for example, in the wake of the Sports Direct inquiry. However, I think there's a case for organisations to look at much broader and more deeply embedded systems of employee representation. The key issue is the extent to which organisations in the UK can compete with their European counterparts. So at the moment there is this very significant productivity gap between the UK and our European counterparts such as Germany and France. And arguably one of the reasons for that is that those countries have workforces who have a voice, a much stronger voice in the decisions which affect their everyday working lives, and as a result are perhaps more engaged and more productive and have higher levels of performance. So I think that one of the key things that the government needs to do is look at ways of supporting more effective structures of employer representation and voice. In addition to that, I think it does need to address some of the issues around enforcement of employment rights, and certainly we'd suggest looking at something along the lines of a Fair Work Commission to actually review the whole impact of employment rights in the UK and perhaps search for new ways of developing a more proactive system so that actually encourages good practice among employers. And one particular idea is one that's been trialled there's one that's been implemented in Australia, where they have a Fair Work Ombudsman whose role is to particularly address some of the issues in more vulnerable sectors and amongst more vulnerable groups of employees.